Good evening, and welcome to the Season 21 finale of Lawyers on the Line. I'm Bob Falsani, a founding partner of the Duluth law firm of Falsani, Balmer, Peterson, Quinn, and Beyer, and this evening's moderator. I hope you have your questions ready for tonight's topic, which is estate planning. Now, the idea of planning for your later years and beyond may feel overwhelming, but these days, even your primary care physician wants to know, do you have a will? Here to answer your questions about estate planning, I'm pleased to welcome tonight's panel. Mark T. Signorelli of the law firm of Mark T. Signorelli, LTD, and Greg Gilbert of the Gilbert Law Office. Please call with your questions at 218-788-2844. And if that's long distance for you, call our toll-free line at 1-877-307-8762. Well, let's start out with something basic. What's a will?
A will, Bob, is simply a written document expressing your wishes regarding the disposition of your property, among other things, signed by you and attested by two witnesses. It can be done on a note card. It can be done on a sheet of paper.
So, Mark, is there any special language you have to have in your will to make it a will?
No special language. You need to be clear about what you say. Make it simple. It's the best formula for putting it together. The only legal requirement is that it be witnessed by two individuals. Oftentimes people think, well, a will needs to be notarized, and that's not true. But two witnesses state clearly and simply how you would like your property distributed, and that should work.
So Ralph's sitting at the kitchen table tonight, and he says, gee, Henrietta, we don't have a will yet, okay? What happens? I mean, he just sits there and says, I give all my earthly goods to Henrietta, and calls the neighbors in, and they witness it, and that's the deal?
Yes, that would constitute a will. Remember that the law basically in a family with a first marriage and children is already printed in the law books. And so he may only be duplicating what it says, but it's still a will.
Okay. And have those kitchen table wills put you out of business then, or?
No. People, they know the basics, but they still come to see a lawyer to kind of fill in the blanks. They have some general questions. What about this? What about, if I want to do distributions during my lifetime? What about, powers of attorney, guardianships, that kind of stuff? So that's kind of where the attorney kind of fits in the role, as we can answer those questions and address those issues.
Now, you said that the law already says if you don't have a will, there's a way that things get divided up?
Yes, and basically in a first marriage family, it's all to the spouse. There are some exceptions for special things for children. But if the spouse is not surviving and there are children, it descends to the children. It just percolates downhill.
Now, with the divorce rate the way it is, it's not always that simple, is it?
No, I think Greg and I share that common notion that second marriages, sometimes third marriages, children of different marriages complicate the situation considerably.
Okay. What's the advice about that then?
Well, in an ideal situation, a will will kind of serve a purpose as a catch-up. You'll be husband and wife, or children will be joint tenants on property. Husband and wife will be joint owners of a house. They'll be joint owners of bank accounts. They'll have insurance policies where they have beneficiaries or retirement plans. Or if you have a child and an elderly parent, oftentimes a child will be co-owner on the bank account. And if you can set that up, a good estate plan will pay attention to those joint ownerships. And so really a will is served as a catch-up, kind of a catch-all for things that are missed. But for second parents, there are several strategies you can use with simple trusts or different provisions in wills to make sure that your children are protected and not everything goes to your spouse's children. Because that's important sometimes.
Greg made a good point, is that often people own their property in joint ownership, beneficiary designations, take care of it. So a will may be the prettiest will in the world, but it doesn't control any property at all. It all passes automatically by operation of law, apart from a will.
All right, we've got a complex question here that we're jumping right into the heart of estate planning. If you receive money from an irrevocable trust, is it taxable? trust written in Wisconsin, but the beneficiary from Minnesota. We're putting you guys to the test here tonight.
Well, a trust itself is, an irrevocable trust is itself a taxpayer. It earns income. It has deductions. And what it pays out often carries out the income to the beneficiary. And to that extent, the beneficiary would be taxable and the trust would have a deduction. It's a field that lawyers and accountants who deal with trusts scratch their heads about a lot, but yes, the short answer is yes.
Okay, that sounds like somebody's got a complex situation though, huh?
Irrevocable trusts aren't used very often, Bob. I mean, it's a highly specialized practice, and so, you know, we generally don't see it a whole lot.
Woman owns her own home, 51 years old, has one son. If anything happens to her, will everything just go to her son?
And the answer is yes. If she doesn't have a will, it goes down and is divided among her children. But what that person may want to look at is adding the son as she's too young to add him as a joint owner. But maybe what she wants to do, there's a new strategy called a transfer on death deed in Minnesota now, where she would continue to own the home, and then when she passes away, title would automatically go to her son. Because if she relies on intestate laws without a will, then she has to go through a probate, which is not horrible, but it's an extra step.
Okay. Now, this, I'm sure you've heard this question like 3 million times, okay? Somebody quit claims their deed, quit claim deed, right? This says quick claim deed, but it's quit claim deed, right?
Yes.
Yeah. Of property to the sons, this real estate. Does she still have an interest in it if she gives it, if she goes into the nursing home? In other words, is there a recapture if she goes to the nursing home for quit claiming to her son?
If she actually quit claims the property, she's cut the strings and the son owns the property. The real question there is, on the nursing home side, has she done it within 5 years of running out of her other money? Because then that gift, and it is a gift, will be deemed to be part of her estate for medical assistance purposes and may disqualify her.
Okay. Now, was it always 5 years, or they've moved back in time here?
No, they've moved back in time. It's been 5 years for a while, but it's kind of been a game of cat and mouse between the state and estate planning lawyers. You know, the state wants to recover as much money as they can from people that move into a nursing home to pay their own care, and residents and lawyers want to plan the way they can to minimize the amount of money they have to pay. So it was 3 years at one point, and then it's kind of crept up to 5 years where it is now.
And that's not an estate tax, that's a recapture by human services.
Yes,
right?
And I like to call it in quotations the 100% tax on your assets paying for your care in the nursing home one way or the other.
You're almost personally hurt if somebody has to pay anything to the government when they die, right?
It's not something anybody really wants to do. I've never had anybody walk in the office and say, well, can I write the check to the government now? It doesn't work that way.
I mean, there must be tears in your eyes if there's any estate tax,
But
right?
when Greg talked about cat and mouse in the, as I call them, the old days, yes, to stay away from paying a state tax, state or federal, people went out of their way to try to avoid that.
You know, on the other hand, you know, someone will say their entire life to have money to take care of themselves when they're in a nursing home or take care of their spouse, and that's what the money's there for. You know, so it, you know, it's kind of also people say, well, you know, if there's a strategy I can use to avoid paying some, I'd like to, but it's not the end of the world if you have to pay for your care. That's what you save for.
All right, here's an interesting one. This comes up all the time, too. Mother left 3 kids the family cabin equally. One sister hasn't used it or paid anything for the upkeep of the cabin all these years. Nothing, no part in it, in 20 years. Now, 20 years later, she says, I want to come back and use the cabin for free. Can they do anything about that?
If mother had left the cabin just outright to the 3 children, so each of the children owned an undivided 1/3, she's as much an owner as the other children, and it may not be fair to those children who, like Horton the elephant, masterminded the nest for all that time, to have the sister come back in and demand her rights without paying for it. It was a lack of planning on mother's part.
Well, if there's 20 years of taxes that these two kids have paid, right? Do they get any benefit for that over the third kid?
Well, they'll probably take an income tax deduction for the real estate taxes paid. Whether they can recover that share equitably or legally, you're the trial lawyer and you as well. That's something I am not certain of, but they certainly have the righteousness on their side.
One option that mother could consider is a cabin trust or a cabin limited liability company. And we're seeing more of those now. And what essentially happens is that, the parent will transfer the cabin into a trust or a liability company, and there'll be an agreement that actually spells out, the children's responsibilities and what they're supposed to pay and contribute to the maintenance of the cabin and what happens if they don't. So, that would have been an option that would have helped, that mom in that situation probably.
My brother-in-law received a cabin from the dad, and there's a brother and two sisters, and the dad just gave it to him because he does all the work and he's helped out with the taxes, and the other kids almost never show up, and when they do, they just come to play, So he just said, this is the fair way. So, daughter got a will form on the internet, filled it out, notarized it. Death occurs. Oh, no death. Do you have to bring it to the courthouse, or is it legal since it's notarized?
If that's all it is, her signature and a notary, it's technically not a will.
Is it in some states? Maybe they picked this form up off of Iowa or something.
I don't know of a state that doesn't have the witness.
It's hard to say, but I agree with you. I think that nearly everybody, now every state, they kind of make their laws the same to try to avoid, the ups and downs. But
what about this idea of, do you have to file a will for it to be official or anything?
You don't have to file it before death, although you can. They put it in a registry where it can be found. It's like a safety deposit box up in the courthouse. But after death, if you're in possession of somebody's original will, the statute says you have to drop it off into the courthouse. You don't have to start the probate, but you have to file it.
Is that a crime if you withhold that then?
I don't know if it's a
well,
crime.
it could be if there's a probate of the estate and they say, well, there's no will, and there is one floating out there, and you know about the probate and you don't disclose it, that could be troublesome. Or if you do know about it and say it isn't and you don't disclose it. I mean, in the old days, the county, everybody used to say, well, I got to file a will with the county, and they would just hold it. But you don't do that now, and I don't have that many people that actually send it up to the county anymore, Mark. I don't know if you do too.
What percentage would do that, you think?
Well, I haven't had anybody do it in years, so probably for me, zero.
I guess they're safe
right
on
now.
that issue then,
Yeah.
about not filing at the courthouse.
One change is they will take a copy of a will now. They didn't used to do that. But if all you have is a copy and you represent to the court that that's the original, copy of the original, that works now.
Well, in the world of copying machines, it's been around for a while, right?
That's right.
Okay. Inherited vehicles from a fiancé in Minnesota from a will, but now is having trouble transferring the titles in her name. She dated the guy for 20 years, but never married, no probate, 3 vehicles, campers, and ATVs. What should I do? Well, there was a will. I suppose there's a question of whether you have to probate that or not, huh?
She would be in title under the will, but the will would have to have some sort of a probate procedure to show that she was designated as the beneficiary.
In some states, can you just bring the will in to the motor vehicles and get the transfer made?
Not to my knowledge, but I don't know the laws of all of the states. So.
I don't think so either, but it's too bad there's not a family relationship there, because the Department of Motor Vehicles is the neatest organization, because if you pass away and say your brother passes away, you take in the title and just represent to them that you're a relative, they'll transfer the title on the spot. They're very accommodating in that.
I transferred my parents' car recently in Florida that way.
Yeah.
I brought the will in, title, said, here's my ID, fine, away it went.
They're surprisingly
Another stolen
easygoing.
car was great, Okay, I got another one of these. This is a revocable trust, okay? Now, you said that irrevocable trusts are not common, right?
Well, they are, because a revocable trust, when you die, becomes irrevocable. And
Okay.
it may stop there, or it may continue for years. Then it's irrevocable.
You have a revocable trust. Can you address issues of passing IRAs and Roth IRAs to your grandchildren? Wow.
The short answer is not in a revocable trust, but once you have died, it can establish a trust for your grandchildren, and that trust, when specially written, can be the recipient as beneficiary of the IRA and Roth. And so it would stretch it out over a period of time.
How do you transfer the IRA? Is there something in the document itself?
Beneficiary designation, but the contract with the IRA provider will provide beneficiary information, give you the forms, but you, like a life insurance policy, you designate a beneficiary.
And does that usually pass outside of probate then?
Often it does, yes.
But this situation with the trusts, it might go through a probate then?
If you want to, I guess, protect, if you want to use that word, the grandchildren, maybe from themselves, the four horsemen are inability, disability, creditors, and predators. You don't want to give them a $500,000 IRA outright, and they're off and running. You pay it, make it payable to a trust that will stretch it out for them.
And then, is this technique of passing IRAs sometimes used to generation skip? You know, go from Grammy to the grandkids?
Yes, you can do that.
But you have to be careful when you deal with IRAs. I mean, the payout schedules, you know, the law is very specific about what happens and how it happens. And even though creditors can't get an IRA, you know, if it's my IRA, when I give it to my children, then they can. So, you know, it's a lot of issues with IRAs, and people should seek help.
I like this one. Is there any law that says the will has to be opened upon death of the person? I know somebody whose husband died 7 years ago, and she still has not opened the will. Hopefully he didn't give the money to the girlfriend.
Technically, if you're in possession of somebody's will, you have to file it in the courthouse. You don't have to start a probate. Again, the will may not control anything if everything passed jointly to the spouse.
Okay. When is probate required?
Probate, not in every case. Some people think that, you know, if I don't have a will, I need probate. If you own real estate, if the decedent owns real estate, then you have to have a probate and certain assets. And it depends on the dollar amount and the value of the property.
You mean if let's say you had a real estate and joint tenancy, that wouldn't require
That wouldn't be a probate. I mean, what a probate is,
Yeah.
it's a petition that you file with the court upon a person's death. And basically the court then approves the will and say, yes, this is an actual will of the person. And they appoint a person to be personal representative or executor. And then you can have different levels of probate. You can have supervised and unsupervised and formal and informal. And as the names imply, you know, you can get very complicated probates with very complicated asset structure, or it can be very simple. Most in this area are very simple.
Remember,
It looks
too,
like we've got to close up here, I think, huh? Are we at the end of our show? That's all the time we have for tonight. No? I guess we still do. Okay.
Remember,
we still got
Bob,
some time. We've got a couple more
10
minutes?
as Greg
Okay.
alluded to real early in the show, a will can not be about property. For young people, the most important thing is nominating the person, the guardian, to take care of minor children, or to appoint an executor to handle business affairs and to maybe handle unruly children.
Okay, that's what I wanted to talk about that tonight sometime. What are the most important things you'd say for somebody that's not really wealthy? Okay, I mean, maybe they got an estate of $300,000 or $400,000 or something like that. What's important about having a will for them?
Picking the executor, somebody to run the show and wind up the estate. If there are minor children involved, nominating a guardian or guardians. Those are the really important things.
Okay,
If you want to make special gifts, you know, you do that in a will as well, or contributions, or gifts to charities. Or if it's a second marriage arrangement, and you want to have your property go to someone that's not, you know, in your line of inheritance, then a will is a good idea. It's essential.
Okay. this idea of what's probate and what's not probate, are non-probate assets sometimes considered for purposes of estate taxation?
Oh, absolutely. A non-probate asset, a good example would be an IRA or a life insurance policy. Those are all taxable in the estate for estate tax purposes.
Okay. So what is the estate tax limit where you start getting taxed federally right now?
$5,250,000 per person.
Okay, so you've got to be pretty well off to start worrying about federal estate taxes.
Yes.
What about Minnesota estate taxes?
Minnesota's at a $1 million threshold and hasn't moved for several years and is unlikely to move. So if you're over $1 million, Minnesota will levy a tax on you.
Okay. So let's say you have a husband and wife, okay? One of them dies. They have a $2 million estate between them. Is there any tax then, state tax?
If the husband's leaving it, for example, all to the spouse, there's a deduction called the marital deduction, which is unlimited. And so the answer to your question is no, not at the first death. It's the second death with the spouse having now the $2 million, that the first $1 million would be exempt, the second $1 million would be taxed.
Okay. And what would be the tax, let's say the spouse that's got the $2 million, all right? The first spouse has died, the second spouse is alive, $2 million left. What's this Minnesota estate tax on that?
It's $99,600.
Okay. And what would the Wisconsin estate tax be on that?
Zero.
What would the Florida estate tax be?
Zero.
What would be the Arizona estate tax?
Zero.
So there seem to be a lot of people that live for 6 months and 1 month, 6 months and 1 day in Florida or Arizona, that kind of thing.
It's actually 183 days, but yeah.
Okay. And that's one of the reasons at least, huh? Especially if they're real elderly.
Yes.
And of course, there's this other taxes involved too, huh?
You don't see them move very often, but that's an option.
Yeah.
A lot of people up here fall between that, when they're under the $5.25 million asset, but they're over $1 million. And so it's you're in that gap. People say, well, I'm safe, but you can't forget about the state tax because in Minnesota it's pretty high.
So if Mrs. Smith has the $2 million left because Mr. Smith died, and she's selecting a nursing home, should she look to Wisconsin then?
Yes.
Okay. Now, we talked about the estate tax part of things. What about gifting away to get under taxation so you don't get taxed?
And that's a common strategy. If you're over $1 million, just go close to it, or anywhere in excess of it, a person can give away up to $14,000 a year without paying gift tax. And you don't want to get stuck with gift tax because that's a high rate as well, and the 35,000 or so, 35%. And it's a nuisance because it's unlikely a person will actually pay gift tax, but you have to file a return. And so it's a nuisance. A person can give away $14,000 a year. If you're a husband and wife, you each can give $14,000 a year, or $28,000 for the both of you. And if you have 4 or 5 children, you could give each child $14,000, or each parent, both parents could give each child $28,000.
28 and 28.
So while it may seem like a small amount, with the $14,000 alone, actually by doing those combinations, it can add up to a pretty good amount.
And on top of that 14, you can pay the child's college tuition directly to the bursar's office, or the child's medical bills directly to the providers. And those are on top of the 14, and they're also not taxable gifts.
Let's say the child is married, okay? So you got husband and wife give Johnny $14,000 apiece, right? And they give Johnny's wife $14,000 apiece?
Yes, sir.
Okay. So that's one way to get rid of some of this excess money if you're headed towards probate land.
Yes.
And to go along with what Mark was saying about educational contributions, also these 529 accounts that are popular now, that allow to pay for college. Sometimes I'll see grandparents that can make contributions to those as well, and those have special rules that are a little more generous for gift tax purposes.
What can you tell us about living wills?
It's one of the things that people should consider when they reach age 18, and something parents and grandparents can talk to their children, grandchildren about, at least having a power of attorney that's financial and a healthcare directive, which is medical, and that includes a living will within it. It's an important backstop. If you did nothing else at age 18, you should do those two things.
What's the living will, then?
Well, a living will, and it's simple. A living will essentially says that if I don't have my capacity to make decisions about my health care, somebody will do it for me. And everybody uses the same form, and there are essentially two parts of the form. You appoint someone to make decisions on your behalf, and then there's a part of the form where you can actually give instructions to that person as to what you would like to have happen in certain life situations.
Now, most of the medical facilities hand those out?
Most of them do, or you can get them off the internet, or you can literally, if you follow enough simple rules, do it yourself. I personally think it's better to see a lawyer.
So this power of attorney part of this, what is that all about?
That's only financial, business, legal transactions. I can think of the number of times my children have been out of town, needed something done here in town, their signature here in town, and I had their power of attorney.
But you have to be careful with the power of attorney. Power of attorneys are the same pretty much form also, but they don't typically wait until you become incapacitated. If you give a power of attorney to someone, they can actually go out and write checks the next day. So you need to be careful with them.
It's effective now.
Yeah, your child surprises you with the Corvette they just bought, right?
That's
Yeah.
exactly right. There are some curbs on that, but you don't want to have to get into them.
All right, so we're going to wind up. I'm sorry I got a little preliminary on the end point. I got confused here, but that's all the time we have for tonight. And I want to let you know that you can have your questions on tonight's topic or any legal topic answered every Wednesday at noon at the St. Louis County Courthouse through the Volunteer Attorney Program's Ask an Attorney service, and call 723-4005 to make an appointment. Remember, you can watch tonight's program and all of our season shows online, ranging from family law and automobile injury claims to bankruptcy and premises liability claims. Just go to www.wdse.org or the Falsani, Balmer, Peterson, Quinn, and Beyer website. I'm Bob Falsani. See you next time on Lawyers on the Line. Good night.